Hey everyone, my name is Rory O'Connell. Welcome. I am the Research Director for Law at Ulster University, and I'm pleased to be chairing this seminar, which is a book launch and discussion for the Law and Practice of Peacekeeping for Grounding Human Rights, written by Rosa Freedman, Nicholas Lemay-Hebert, and Siobhan Wills. And we have with us Professor Nigel White as a discussant. So the seminar today is being live streamed on Facebook, and we are also recording it. So we will post it later on our YouTube channel at TJI. So I'll first of all say a little bit about the book and who we'll be hearing from today, and outline the format. Now, we will have the authors do some short commentary on the book before we turn to Nigel White to offer his thoughts on reading the book. And then we'll go back to the authors before opening it up for any questions or observations. There will be a chat and a Q&A function that members of the audience can use if they want to ask any questions. As for the book itself, this is an exploration of the highly controversial United Nations Stabilization Mission in Haiti. The UN's legacy in Haiti is not all negative, but it does include incidents of sexual scandals, the divisive use of force to clean up difficult neighborhoods, as well as a cholera epidemic brought inadvertently by Nepalese peacekeepers that killed more than 8,000 Haitians and infected more than 600,000. The book presents a unique multidisciplinary analysis of the legacy of the mission for Haiti. It presents an innovative account of contemporary international peacekeeping law and practice, arguing for a new model of accountability, going beyond the outdated immunity mechanisms to foreground human rights. The authors are Rosa Freedman, Nicholas Lemay-Hebert, and Siobhan Wills. Rosa Freedman is Professor of Law, Conflict and Global Development at the University of Reading, and she has published widely on the UN and human rights, serves on the UN Secretary General's Civil Society Advisory Board for the Prevention of Sexual Exploitation and Abuse, and acts as a specialist advisor to the UK government. Nicholas Lemay-Hebert, who cannot join us today, is a senior lecturer and director of research at the Department of International Relations, Coral Bell School of Asia-Pacific Affairs, Australian National University. Prior to joining ANU in 2019, Nicholas worked as a professor at the University of Quebec and senior lecturer at the University of Birmingham. His current research interests include intervention issues, in particular local resistance to international interventions and the political economy of interventions. Siobhan Wills is director of our Transitional Justice Institute at Ulster University, and she has led 2 Arts and Humanities Research Council funded projects on human rights and the excessive use of force in policing and law enforcement. She has co-directed 2 award-winning films, It Stays With You, Use of Force by UN Peacekeepers in Haiti, and Right Now I Want to Scream, Police and Army Killings in Rio, the Brazil-Haiti Connection. And then we are joined as discussant by Nigel White. Nigel is holder of the chair in public international law at the University of Nottingham and co-director of the Nottingham International Law and Security Centre. He served on the Research Excellence Framework and Research Assessment Exercise panels in 2014 and 2020. His expertise lies in the fields of United Nations law, peacekeeping law, sanctions, arms control law, the regulation of private security contracts, war powers, and military justice. He has undertaken a number of funded research projects, including on the regulation of private military and security contractors, democratic accountability and the deployment of troops, human rights and post-conflict situations, the role of national courts and international law, counterterrorism and the rule of law, and the role of private security actors in extractive industry. He has given written and oral evidence to the UK House of Commons Constitutional Affairs Committee, the Foreign Affairs Committee, the All-Party Parliamentary Inquiry into Terrorism, and has made a written submission to the Iraq inquiry. So we're very pleased that Nigel can join us to act as discussant for this book today. So we're going to start with some words from the authors. Rosa and Siobhan, would you like to kick us off?
Thank you, everyone. Thank you all for coming. And I would like to start by thanking Nigel for being so generous with his time in reading the book, and also for being here, and also to thank Rory for chairing this event. And I'd also like to say what a privilege it was to work with Rosa and Nick on this book. I've heard people say co-writing is very stressful and very difficult. Co-writing with Nick and Rosa was great. They're really wonderful people to work with. And I think maybe that was because we came from a similar experience. All three of us have worked in Haiti in collaboration with civil society groups. And we've all been working on addressing the impact of the UN Stabilization Mission in Haiti, MINUSTA, on the marginalized communities in which most of the mission's security operations took place. Rosa, Nick, and I were working in Haiti over roughly similar periods of time, working with different groups, and we were working on different specific issues. But a common theme that emerged for all three of us was the disjunction between the UN's commitment to upholding and advancing human rights protection globally and the way in which the mission operated in Haiti, which was to act as if it had no human rights obligations towards the communities in which it operated. And this was evidenced by the fact that residential communities were subjected to excessive use of force, using techniques and weapons more appropriate to a war scenario, resulting in very high Haitian casualties, including many children, and resulting also in destruction of homes and livelihoods. Suffering was compounded by extremely high levels of sexual abuse, and by the mission's negligence in bringing about a cholera epidemic that has killed thousands. And that horror has been compounded by the UN's attempts to deny responsibility. This theme, that is the disjunction between the UN's stated human rights commitments and its failure to uphold them in its own operations, is not unique to Haiti. And I think it has reverberations beyond UN peacekeeping. There is, to my mind, a conflict between states and international organizations' approaches to security and their approaches to human rights. And that's a conflict that's recently come more prominently into public discourse with the Black Lives Matter movement, particularly since the killing of George Floyd. But it's not something new. It's at the heart of the UN system and many other systems of security and human rights regulation intersections. The UN Office of the High Commissioner for Human Rights has been committed to entrenching human rights across all areas of the UN for several decades, but that commitment has made very limited inroads on the areas of the UN that are dedicated to security, at least in the context of the UN's own operations. Our security systems, I'm not talking about the UK, but internationally and in general, were established to maintain the structures and power imbalances that were originally developed to protect the interests of the states and political elites that had benefited from European colonialism and slavery. And looking globally, to a large extent, the people whose human rights are most likely to be violated frequently and on a large scale are residents of communities that were subjected to discrimination and abuse in the slavery and colonial eras. And it's no coincidence, I think, that the Haitian communities that suffered most harm from MINUSTA's security operations were the extremely marginalized communities. They were the ones most likely to be subjected to military operations. They were the ones most vulnerable to sexual abuse, and they were the ones most likely to die of cholera. And this is a pattern that exists all over the world. Residents of marginalized communities are more likely to be subjected directly to human rights violations. And at the same time, human rights violations are being enabled by political and security systems that choose to ignore the rights of the poor and fail to afford the poor equal rights to everybody else. Very often the poor are presented as a security threat. Their very existence is a threat to everybody who is not so poor. In my view, the UN must take active steps to address this imbalance if it is to maintain credibility as a human rights body. The commitment to entrenching human rights in all areas of UN activity must include the UN security operations, especially its peacekeeping operations, which are aimed at protection and not at waging war. And that's what I'm going to say for my bit of the introduction. And I'm going to pass over to Rosa. Thank you very much.
Thank you very much. And I echo my thanks to Rory and to Nigel, but also to you, Siobhan. Nick and I have written together for many, many years, coming up a decade now. Opening up our collaboration to someone else was always going to be a bit a bit of a throw of the dice, and it was an absolute pleasure to work with you on this. I mean, when I think back about how we got involved with writing about Haiti, Nick, who's not here, has spent many months doing research in Haiti, very much sort of a critical lens of research in Haiti, working at this sort of local level, and being very much part of the communities that resist the UN, or in fact, international interventions generally. And I came in looking at the UN in terms of accountability for the cholera claims, and thinking very much about the UN as a top-down international organization. But where we met in terms of meeting of minds, and where we meet with Siobhan, is foregrounding human rights throughout all of the work that we do in Haiti. You can look at the UN in Haiti or in other peacekeeping and stabilization missions, and you can see that it is a hybrid sovereign power. That it comes in places like Kosovo or Timor-Leste, it comes in and takes over as a full sovereign power. But in places like Haiti or in current peacekeeping operations, there'll be times when the UN takes on the role of the state. And there are times when the UN steps back and allows the state to take on the roles of the state. And if we're thinking about the UN as a hybrid sovereign power, we have to think about the UN as being bound by international human rights laws, just like any sovereign state would be bound. What we saw in terms of cholera and the cholera claims, what we've seen in terms of sexual exploitation and abuse, what we've seen in terms of use of force, is the UN not upholding international human rights law and not adhering to the human rights by which it's bound, or we argue it's bound, when acting like that in Haiti. Now, I'm not a scholar and an expert on Haiti, but to understand the resistance to the intervention of the UN in this stabilization mission, you have to understand a little bit of the history about Haiti generally and the background of international interventions. Haiti is the first Black sovereign state. It's the first state to overthrow colonialism, to get rid of the slave trade, and by doing so, it paid back billions to France in sovereign debt to pay back for those slaves which France considered its property. So Haiti, which is so resource rich and at one point produced 50% of the world's sugarcane, is so underdeveloped because it had to pay back this debt. And because it was the first Black sovereign state, right? If we're thinking about sort of the slave trade and about the way in which Haiti was created as a country with none of the native or indigenous populations left because they were all slaughtered and slaves were brought in from Africa, it was also a threat to the colonial, empirical whites generally. And so this narrative that Haiti requires international interventions is a racist narrative, but it's a narrative that remains even today. This idea that Haiti is unstable, that it's not able to, that Haitians aren't able to vote for their own government, that the international arena will come and intervene if they don't like who is elected. And it's only with those complexities and understanding the history of the country and also the history of states that credit Haiti with their freedoms, states like Venezuela and Bolivia that look to Haiti and say, we only became free from colonialism because Haiti stood up to become the first to throw off their colonial rulers. It's only through understanding all of those complexities that you can start to understand the relationship between Haitians and what was then minister and is now then became Minajust, but international interventions generally. I think what made this book such a pleasure to write was bringing together three different perspectives, being able to learn from one another. I always say I'm an international lawyer who doesn't do very much law. So actually having to engage with the kind of law around use of force that Siobhan does, which is real law. And then, but I bring the diplomacy side and bridging the gap with international relations, and Nick brings with him a critical social science expertise and a particular understanding of the context in Haiti. So I thoroughly enjoyed writing the book. I don't know how much anyone will enjoy reading it. I've seen a couple of reviews where people say, yeah, this is a great book, and they're my favorite reviews because, our job is to engage with one another critically. But that's a little bit of background from me as to why we weren't just looking at Haiti and the UN, but also the legitimacy, the fundamental legitimacy of should the UN have been there in the first place? And if it was, why was it committing these human rights abuses?
Thank you, Rosa, Siobhan. Fascinating introduction to the book there. And we'll turn now to Nigel for his comments.
Thanks, Rory. It's a great book, but no, I won't start like that. I'd like to start by congratulating you on all three of you on the book. I think, I mean, I did enjoy reading it. I was saying to Siobhan before we started, it's short, but it's packed full of analysis, evidence, critical evaluation, and I think it does go to the heart of the problem that the UN has now with its peacekeeping function. It's moved from strict impartiality, neutrality, non-intervention towards being an interventionist, and an interventionist with an agenda that I think this book shows does not have human rights at its heart, when bizarrely, paradoxically, the UN claims that it does. So I think it's incredibly important piece of work. And it sort of made me reflect, because when I started as a PhD student in the mid-80s, part of my thesis was on peacekeeping and how it's really fundamentally changed. So different now, and the legal problems are different, and solutions are more complex than they were, and perhaps than they ought to be. And I think the book really does sort of shine a spotlight through that complexity by showing how if the UN simply embraced human rights and accepted it was obliged by it, not just sort of a pick and choose sort of approach to human rights, which it has, then it is bound by human rights law, but it operationalizes that, then the whole thing would change. And hopefully my comments will explain that a little bit. But it is the book that provokes these comments. I'd like to say that at the start. So I think it makes a number of major contributions to the book, and I'm going to highlight those in a minute. But just to sort of set the context for people that might not be too familiar with peacekeeping. One of my favourite authors on peacekeeping is Finn Sejersted, who was analysing the first peacekeeping operation in 1956 in Suez, and he likened it to the peacekeeping operation to being like a plate glass window, acting like a fragile barrier between former belligerents, but providing an opportunity for a temporary ceasefire to develop into a lasting peace. The force was impartial in a very strict sense, consensual, and was restricted to the use of force in strict self-defense. It didn't challenge sovereignty of the state or states. It didn't exercise any public powers of arrest or detention, for example. And these peacekeeping principles were grounded in international law, in the ideas of sovereignty, non-intervention, non-use of force, and very much reflected the values of the non-aligned movement at the time. And Dag Hammarskjöld, the UN Secretary General at the time, really shaped peacekeeping, and he crafted the sort of legal framework for peacekeeping during UNEF, really. Sort of made it up as he went along, but it really reflecting these basic principles of international law. So it has a basis in international law, and it's the framework by which we still judge peacekeeping operations. The holy trinity of peacekeeping principles: impartiality, consent, limited use of force. You read any UN policy document on peacekeeping or any report from the Special Committee on Peacekeeping, and those three principles are still referred to. And it even refers to them in the context of its modern stabilization operations. And most of the attention on those stabilization operations focus on Mali, Central African Republic, and the Democratic Republic of Congo. And Haiti is the one that is often missed out of that sort of analysis. And I think the book obviously fills that gap, but it does more than that. But in these stabilization operations, as they're now called, there's clear evidence that peacekeepers operate beyond the holy trinity of principles. They confront armed groups and spoilers and use force proactively rather than defensively. They support the government. They're often fighting alongside government forces or operating alongside government forces. They're helping to extend the government's effective control over the country by the use of force if necessary. They regularly use public powers of arrest, detention, and the use of lethal force. And this is where the sort of smokescreen of international humanitarian law is often deployed, because in Mali or the DRC, there is an armed conflict, or at least in parts of the country. And this leads to the whole of the peacekeeping operation to be framed more towards the law of war than the law of peace. And the sort of restrictive framework that formerly governed peacekeeping operations seems to have given way to a permissive framework governed by the laws of war. This was supposed to be exceptional, that peacekeepers normally were protected, they were not combatants, but exceptionally they could become involved in an armed conflict. And that was recognised finally by the Secretary General in 1999 in a bulletin on IHL. And the book very strongly argues that that bulletin needs to be matched by a bulletin in human rights law. And I totally agree with that. Because, as I'll hope to show and the book shows, human rights law is the norm. It should be the applicable law to everyday peacekeeping activities, and IHL should be the exception. So it's bizarre that we have a bulletin on IHL, the exception, and not a bulletin on human rights law, the norm. Okay, so I think, having set the scene, just the three major contributions of the book, as I see it, is, first of all, leading from what I've said on the applicable law. In analysing in depth the operation in Haiti, and it really is a really good example of a case study serving an excellent broader purpose, you're sort of removing the smokescreen of IHL, of laws of war, because there was no armed conflict in Haiti, and the book makes that absolutely clear. So this is an operation that can't sort of use the excuse that there may have been an armed conflict in part of the country and that required peacekeepers to act accordingly. The smokescreen of IHL cannot be thrown up to disguise the fact that modern peacekeeping operations, including Haiti, operate beyond the normal constraints of human rights law, of the law enforcement paradigm that should govern those operations. They seem to operate more in a sort of no man's land between peace and war, a grey area that's sort of suggested or created by the use of the Security Council using Chapter 7 to mandate force. It sort of creates this idea that somehow we're in this state of exception between peace and war, and somehow peacekeepers can sort of borrow some principles from IHL for their normal operations. Clearly, that is legally wrong, and also militarily and practically very problematic. The book makes it clear that Security Council resolutions which authorize a force, this is at page 117, they only deal with the jus ad bellum. They're only a reason for the use of force. They're not the applicable legal framework to the actual use of force. That is still governed by, exceptionally by IHL, international humanitarian law, if there is a armed conflict, and if peacekeepers engage in that conflict, IHL is applicable. But normally, the applicable law is human rights law. It's the only universal standards governing, for example, the use of force or the detention of individuals, and so obviously of relevance to the practice of peacekeeping. So basically, if peacekeepers are not engaged as combatants, which is exceptional, they are bound by basic human rights law. And that is the law governing law enforcement as codified in 1990 by the General Assembly. And the book points this out clearly. Peacekeepers are really no different in this way to police officers. They are soldiers, but they are acting in a law enforcement capacity and are restricted to using force in self-defense and in defense of others. The problem here, I think that, I'm not saying the book should have addressed this, but it made me think about this problem. You're applying a law enforcement paradigm to soldiers, and yet soldiers are not trained or equipped to act as police officers. And, you know, we've had experiences like this in the UK, where the soldiers in Northern Ireland were governed by the normal standards of criminal law, but they were equipped with heavier weaponry than a police officer, resulting in excessive use of force. This is the problem. You're using soldiers to perform essentially a police function. Then I think that is a practical problem that the UN needs to tackle. But the fact that the peacekeeping force is perhaps more heavily armed, is operating in a dangerous, often violent environment, doesn't change the rules. They're still governed by the basic standards of human rights law. And it doesn't mean that peacekeepers can't use force if they are threatened, or if civilians under in their areas of deployment are threatened. It doesn't mean that lethal force can't be used to protect the peacekeepers and individuals, but that force should be defensive and reactive and shouldn't be used as some sort of solution to the instability caused by violence in the host country. And this is where the book, I think, is very precise and reveals the problems the UN has. And I think it was page 122, it shows that the UN doesn't apply human rights law, at least clearly, to peacekeepers, to the military component. But it has made it clear that human rights law applies to the police component of a peace operation. So this is the pick and choose approach I mentioned before. Yeah, human rights law applies to the police, but now not to the military component. It shows the UN realizes it should be accepting human rights law, but the interesting question is why it doesn't accept that it's clearly applicable to the military component. And here the book again gets under the surface, and it reveals in its interviews with UN people involved in Haiti, some in the UN think that human rights law is the applicable framework. Even military officers interviewed suggested that, while others suggest that it's the Security Council mandate under Chapter 7, which somehow generates a wider and uncertain legal framework. And the evidence in the book is that the latter view seems to have prevailed, at least in practice, and also in the standards being applied by the UN in its policies on the use of force. For example, in defining proportionality, when force is proportionate, the UN standards seem to prefer an IHL proportionality standard, which is much more broad and expansive than the human rights equivalent. So it's whether it's confusion caused by the use of Chapter 7 mandates whether it's deliberate misinterpretation of the law, or whether it just simply reflects a genuine lack of agreement in the UN, with the result that that uncertainty is exploited. I don't think the book can answer that question. It can highlight the problem. But then the book shows how this permissive rather than restrictive approach to the use of force led to offensive action in Haiti against criminal gangs by the peacekeepers in densely populated areas of Cité Soleil, for example, 2005 to 2007, including continuous fire from helicopters with numerous instances of collateral civilian losses. And the fact that the UN uses these terms like collateral damage and civilian in this context, as the book clearly shows, it reveals that the UN views the situation as somehow closer or akin to an armed conflict, even though it was not. The invocation of Chapter 7 in the authorizing resolution seems to trigger an approach to peacekeeping which borrows from IHL, even in situations short of armed conflict, when the applicable law is human rights law. And the book clearly gets to the heart of that issue. And the argument that the UN seems to prefer is that a human right, well, seems to sort of infer, is that a human rights standard would not be adequate for a peacekeeping force to do its job. But as I've said, it doesn't restrict peacekeepers from defending themselves or defending civilians, the two most important tasks. Besides which, it's just unrealistic to think that a force of 10 or 20,000 peacekeepers within a country can actually forcefully bring peace. It is just militarily impossible for a peacekeeping operation to do that. So to push peacekeepers towards this law of war paradigm is actually just going to lead to greater loss of life. The book also, in addition to highlighting the problem with the use of force, the unconstrained use of lethal force, the book is also, the second contribution is on sexual exploitation and abuse by peacekeepers, which has become an endemic problem in peacekeeping operations. And it made me think whether the actually, what I've just been saying, there's a link between the increasing coercive, combatant nature of peacekeeping and the sort of almost increase in SEA that is occurring, whether that behavior encouraging peacekeepers to be combatants encourages other forms of misbehavior. I don't know, but it just struck me that the two things are increasing problematically and might be linked. The failure to eradicate SEA by the UN shows really the structural weaknesses of peacekeeping operations, where peacekeepers, I'm talking about the military component here, who are committing acts of sexual abuse and exploitation, effectively have immunity from the host state, cannot be prosecuted by the UN because the UN doesn't have the competence to do so, and so remain dependent upon the troop contributing nations to exercise their jurisdiction in an effective way, which, as the book shows in the case of Haiti, and this is the same with all military operations, the TCNs do not effectively prosecute abusive peacekeepers. And the book makes some very telling points here. Page 54, it says, it looks at the issue of why the host state doesn't really have a role in the punishment of peacekeepers, when actually it is, the citizens of the host state that are the victims. And the book points out that the removal of the host state jurisdiction results in a lack of access to justice for victims. That highlights the problem with the legal framework centering on perpetrators and state sovereignty rather than on victims and human rights. And that is the sort of book in a nutshell. You know, the victims and their rights and their access to justice are secondary or not even an issue for the UN. It's about how we accommodate the TCNs. We've got to get them to contribute troops. We don't want to offend them too much. We'll impose some measures, but we can't go too far because we won't have any troops to deploy. It's all about power, and perceptions of security rather than about rights. So the prosecutions for sexual abuse in Haiti appear almost non-existent, which is remarkable, even though the clearly documented examples in the book, unearthed in the book. So the UN and TCN's, two contributing nations, are completely failing here. The lack of clarity in the UN's approach to sexual exploitation in its understandings of transactional and survival sex, for example, is fully exposed in the book. This is compounded by the hierarchical structures of Haitian society, has led to very few instances of sexual exploitation being reported to the UN, even though it clearly is present, except where paternity claims have been pursued, and they've been pursued without success. The UN and TCNs are simply failing to provide victims with access to justice, something for which there is no excuse. And then, so really interesting discussion on SEA and analysis of it, and sort of advocating a human rights approach which should be adopted across the UN operations generally. And then that leads me to the third contribution on the way the UN has responded to the cholera outbreak. The UN is primarily responsible for that. Whereas you can say with SEA, that is a responsibility that should be borne by the perpetrators, the TCNs and the UN. The UN for failing to stop it, the TCNs for not disciplining their troops properly, and the perpetrators obviously because they did it. With the case of the cholera, it clearly is, you know, the UN doesn't have anywhere to hide. It is responsible for the negligent introduction of the disease into the country, the poor construction of the faulty sanitary system in the Peacekeepers base. And it's not accepted its legal liability, only moral responsibility. And as the book shows, a sort of voluntary approach to remediation. And the discussion in the book about the UN's use of immunity to successfully prevent suits being brought in private law, its failure to set up alternative means of dispute settlement for those affected is really damning. It effectively shows that the UN is able to determine both the extent of its immunity, choose whether to compensate the victims of its negligence, and decide when and where human rights obligations attach to it. Through its case study of Haiti, its careful exposition and analysis of excessive lethal force, sexual exploitation and abuse by peacekeepers, and the cholera outbreak, the book really shows the inadequacies of the UN's policies and practices, and its failure to create a clear, effective, and enforceable legal framework within which peacekeepers should operate. To finish, the conclusion of the book offers a way forward for the UN to restore both the legitimacy and legality of peacekeeping. And I'll quote, it says we need to bring peacekeeping practice in line with international law and formally recognize the applicability of international human rights law to all UN operations, and recognize that outside the conduct of hostilities, all decisions and actions that affect the rights and well-being of human beings should be governed by international human rights law, not international humanitarian law. It requires that missions be accountable to the people directly affected by their operations, such as the people living in the mission's areas of operations, and not just host and troop contributing states and their political elites. I think that is precisely the prescription needed. Both of these elements together are essential. First, you need a clear human rights compliant legal framework for peacekeeping operations. And secondly, an alignment of that framework with human rights-based approaches to accountability. It's essential that the UN recognises finally human rights law as the governing framework and puts humanitarian law in the exceptional box. And it needs to clearly articulate this to peacekeepers and not keep borrowing concepts from humanitarian law on proportionality, protection of property, and many other instances where the language of the law of war has crept into peacekeepers' rules of engagement somehow. And in order to ensure that misbehaviour is addressed and punished, those individuals whose rights have been violated have to have access to justice against the perpetrators, against the troop contributing nation and also the United Nations. A human rights approach should ensure that those who hold the rights have the means to enforce them. At the moment, this doesn't happen. The decision to punish and or remediate is solely in the hands of the UN and or the troop contributing nations. The victims are simply objects, not subjects of the law. And in the end, this is what the UN seems to be afraid of. It's afraid that if it goes beyond its rhetoric of promoting human rights and actually recognises that the UN has duties to individuals and that the victims of abuse at the hands of peacekeepers have enforceable human rights, the true extent of the problem will be unveiled and will expose the UN to the floodgates of claims and litigations. That's what it's really afraid of. But you can turn that on its head. Because to expose the UN finally to such claims should force the organisation to significantly improve the behaviour of its peacekeepers. And only proper accountability will ensure that that behaviour is improved. So I think the book, by focusing on these three areas, use of force, sexual abuse and exploitation, and the sort of negligence of the peacekeepers, the carelessness and the unwillingness of the UN to recognise its liability, it really reveals the UN has lost its way in peacekeeping, and it's ended up by blurring standards from different areas of law, when really it should be recognising that the applicable law is human rights law. And if you start to accept that in your operations and practices, then it should become a lot clearer, and it will enable the UN to get back to its peacekeeping roots, I would argue, which it seems to have lost. I'll stop there, but thank you.
Thank you, Nigel, for acting in so exemplary a manner as our discussant today. So we're going to hand back to Rosa and Siobhan first, if there's anything they want to respond to in relation to Nigel's commentary there. And meanwhile, if anyone in the audience has any questions, please use the chat function or the Q&A function to ask them for our authors or indeed discussant. Rosa, Siobhan?
Firstly, Nigel, thank you so much for reading it so carefully. I don't think anyone's read it that carefully. I really appreciate the sort of way that you engaged with it and the level that you engaged on. I think something you said made me think about Alex Gilder has written a review of it. Alex is now a colleague of mine at Reading, but had written this review of our book, where he said we sort of missed this opportunity to really think about Haiti within the context of stabilization operations. because I in many ways lump in stabilization missions with peacekeeping. And in many ways, I'm looking at peacekeeping over the last few decades, not peacekeeping going back to its actual roots, as you were talking about. And it does make me wonder what is the future of what's going to be the next cycle of peace operations and peacekeeping, because you're absolutely right. We can't keep borrowing from humanitarian law and warfare, essentially, to deal with peacekeeping. Peacekeeping operations are now about state building and development and delivery of aid, but also supporting governments, building justice systems and schools and everything else. And it's no longer about boots on the ground and guns in the hand. Or if it is, that's only one component. I don't have an answer to it, but I think listening to you really made me think again about what is going to come next. And we don't know, sitting here, whether the UN will exist in a week's time. You know, I think at 3 o'clock, I'm sure other people have set their clocks for it, but we're going to listen to this Security Council discussion on Russia and Ukraine and the shifting of the blame to everyone but the perpetrators. It could well be the beginning of the end for the UN and the beginning of some form of new multilateral organizations. And if so, what's going to be with peacekeeping? You know, NATO aren't brilliant at peacekeeping, and certainly they're not brilliant on the human rights issues. They've only just drafted a preventing sexual exploitation and abuse policy in the last couple of years. So I'm not necessarily looking to them, and the African Union doesn't have a lot of policies on a lot of human rights issues in terms of their peacekeepers, and same with ECOWAS. But we're kind of moving into the dawn of a new era, and it might be about time that when people like you and Siobhan, definitely not me, draw up sort of rules of engagement for how peacekeeping operations look, that they start to foreground and centre human rights concerns.
Thank you. Thank you, Nigel, for such a detailed, rich reading of our book. I've forgotten some of the things that we wrote. So thank you. And thank you also, Rosa, for your insightful comments on where we are now and where we might go, or what the crisis we are facing now. In listening to you both, one of the things Nigel reminded me of with us, that when his reference to that the UN accepted that its police forces are subject to human rights, is that this argument about the extraterritoriality of human rights that has been going on for, I don't know, ever since I started doing my law degree. Clearly the UN has accepted if police have to comply with human rights standards when they're in Haiti, then there is at least a frame in which extraterritoriality applies, so that they can't just say, it doesn't apply to our peacekeeping troops because they were operating extraterritorially. And I think that step that they have recognized that we can't just ignore the applicability of human rights when we're abroad, partly because we are supposed to be protecting human rights, and to ignore it just makes no logical sense and undermines the legitimacy of the UN. But clearly they've accepted it with their police forces abroad, their peacekeeping police forces. So why not with the troops? And I think there's this issue about the tension between security, military operations, and the human rights wing of the UN and all the arms and permutations of the UN human rights system, which is very broad, that there is a conflict there, and that there seems to be a reluctance and a hesitancy from the human rights sector to impinge on the security military sector, and the security military sector just they're not going to be impinged on. Thank you very much. And it struck me. I'm now working. I suppose I'm coming up to. I'm now working. I have been for the last few years looking at police violence in Brazil, and it is connected with the operations in Haiti, because the police violence in Brazil, the mission in Haiti, and this is not to say that the problems in Haiti were linked to the fact that they were Brazilian, but that there is a link in what is happening in Brazil because of the link between the experience of a Brazilian-led mission in Haiti now operating in Brazil, doing policing functions. And one of the things that I found in the campaign for General Bolsonaro's presidency, General Heleno, who was the first mission commander of MINUSTA, and he was in charge of some very disturbing operations in 2005, or in one of which 22,700 bullets, 78 grenades, 5 mortars were deployed in an overnight operation in a residential area, very poor area where people living mostly in salvaged corrugated metal shacks, basically. And leading to, well, since there was no investigation by the UN, between at least 30 and more than 60 deaths, but no figures because the UN never investigated. But anyway, General Heleno was on Brazilian television campaigning in favor of the election of Bolsonaro. They have a very close relationship. Heleno was described as a father figure to Bolsonaro. And he just talked about the mission in Haiti. And he talked about having very flexible rules of engagement in Haiti, and how he wanted to apply those same flexible rules of engagement in the favelas in Brazil. I mean, the policing in the favelas in Brazil is already very violent, but they wanted to increase that. And he actually said that the rules of engagement in Haiti permitted the commander on the ground, and he specified and reiterated the commander on the ground, not the commander overall, to authorize lethal force to anyone that they suspected of having a hostile intention. And that hostile intention, he said, included anyone that was armed, that was stealing goods. And that, to my mind, is a shoot to kill policy. If somebody is armed and they're not threatening anybody's life, they're stealing, in a context outside, even in a armed conflict, I'm questionable that someone who is not a combatant, who is stealing goods, should be permitted to be shot. And that's another thing that came into my mind as Nigel was talking about the spoilers. What legal frame does spoilers come into? Who, shooting at spoilers, they're not combatants? But at any rate, that he was arguing that the UN had, under its rules of engagement, the authority in his mind, whether it did or not, to shoot anybody armed that was stealing goods. And he wanted to apply the same thing in Brazil. And Bolsonaro got elected. He's still being criticized, but General Heleno is still there. They are shooting people in the favelas they're firing from helicopters. So people are being shot without doing anything, not even stealing goods. But because of their operating a war policy to control gang crime, to control the war on drugs in the favelas. And this has become a global militarized problem where you're drawing on law of war to deal with domestic violence, drug crime, basically. And I found that very disturbing that this could be on television and that there was no comeback for General Heleno for actually describing this. But I was looking back when I heard this at 2000, when he was actually a mission commander in Haiti at the time. He said publicly on Haitian Radio Metropole, that we must kill the bandits. And then he said, but it must be the bandits only. But there was no war. Who are the bandits? That if, the British Armed Forces said that in Northern Ireland, I think there would be, outroar. This is a shoot to kill policy. You can't kill people simply because they're armed or causing. But apparently, according to the UN, nothing happened. There was no comeback. And then I pushed a bit. Was there any comeback? And he did resign. And according to some Brazilian newspaper, he was pushed to resign, but it was all kept quiet. So we don't know whether he came to an end of term and voluntarily resigned, or the UN said, look, this was unacceptable, you've got to go. But it's pushed under. And that I think, is problematic in itself if the UN is not transparent in its standards. If you are advocating or you're promoting human rights, that you want to uphold and maintain human rights, and the UN is advocating that this is a core theme for it and a core role, then not only must you apply human rights, and you must set it out and have a framework so that all the people who are working in whatever field under your authority apply human rights and know what the frames are and what the rules are, but you must almost also communicate your obligation to apply human rights, have systems whereby the people in the countries where you're operating know what rules apply to you, what circumstances they can be fired at, who they can go to if there's a violation, and know that that there is a route to get some access to justice, some route to be able to claim that their rights have been violated. And when I was in Haiti, there were people who said that they went to the UN again and again. They would turn up at the UN doors and say, my husband's been killed, my child's been killed. And the MINUSTA mission would say, it's all right, we'll call you, we'll get back to you. And they didn't. And, after month of dragging yourself when you don't have very much money up to the UN gates to say, look, I'm waiting, and nothing happens. Thank you, that's my rant.
Thank you, Rosa and Siobhan, for those very eloquent responses to Nigel's comments. We are actually at time and we don't have any questions as it happens. And so I imagine you do have other commitments, so we will wrap up if that's agreeable. But I would just really like to thank all of you. That's really been an enlightening and inspiring hours discussion on the current state of peacekeeping. It's particularly resonant for me because I happen to be reading some of the debates in the British newspapers at the moment about the history of colonialism and a government minister proposing teaching the pros and cons of colonialism, which seems a rather problematic approach. And I was struck by many things, but particularly struck by the description of this as a story of colonialism and its aftermath, and how our modern world is still shaped in many ways by the history of European imperialism. So I am very grateful for that and for really the masterclass level discussion of peacekeeping and stabilization missions. So thank you, Rosa and Siobhan, for joining us to talk about your book. And thank you, Nigel, for what was really an exemplary discussant role today. So we'll make this all available as well on our YouTube channel. But thank you. And I wish you all a good afternoon or morning or evening or wherever you happen to be in the globe. Okay, thank you.
Thanks so much, Rory. Thank you.
Thank